I'm Judge Jackie Powell, and we're back on the docket. We will begin with the first appearance docket, and then we'll go to the hearing docket. So Janelle Livingston, she bonded. Thank you.
Correct, Judge.
And then Nathalia Johnson,
Medical reset, Your Honor.
medical reset. And then we know Kimani Pierce. It's not here. And then John Moxia.
He's here, present, Judge. Come on up. There, Your Honor.
Hi, sir. This is a municipal ordinance violation.
Yeah.
Okay, so what do you want to do with this case today, sir?
Can we resolve it now?
All right, we can. I'll sentence you to adjudication and time served. Is that okay?
Thank you, Your Honor.
Well, then please raise your right hand, and I'll take a plea from you. Do you swear or affirm to tell the truth?
Yes, Your Honor.
You can put your hand down. Sir, do you understand everything that's going on here today?
Yes.
How do you say your last name?
Moshe.
Moshe. All right. So, Mr. Moshe, do you need any more time to speak with an attorney?
No, Your Honor.
And you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No.
And you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
I'm a U.S. citizen.
All right. Then what plea do you wish to enter, Mr. Moshe?
Excuse me?
Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and you're sentenced to adjudication and time served. Good luck, sir.
Thank you, Your Honor.
You're welcome. And then Stephen O'Neill. Is Mr. O'Neill still on medical loan?
Yes, he is.
All right, thank you. And then Darian Anderson. All right, Mr. Anderson, you're before the court for an ad charge. This is a possession of weapon or ammo by a convicted felon. How much bond does Mr. Anderson?
He's got no bond holds on VOPs and a $10,000 bond on an aggravated assault. Your Honor, I'd be requesting a $2,500 bond on
All
this
right.
ad charge.
So, Mr. Anderson, the court finds probable cause, and your bond on this is charge number 5, is $2,500, okay?
Yeah, okay, can I talk to the public defender?
Sure.
Well, I guess you need to call yes. Robert Pellegrino,
Judge, I'm gonna put this on recall if it's possible. I need to
put
be
what
able
on
to,
recall?
I don't have a PC for it and I wanna read.
On, what are we talking about?
Pellegrino?
Okay, Marcus Jones,
Ma'am, Mr. Jones is in court, Your Honor.
Mr. Jones is in court, okay? Jeffrey Prescott,
Mr. Prescott is here, Judge at Maine. He's approaching. Come on up, Mr. Prescott.
all right, Mr. Prescott is before the court. Charge number 1 is possession of controlled substance without a prescription. Number 2 is possession of cannabis, 20 grams or less. Number 3 is possession of drug paraphernalia. 4 is a misdemeanor capias. And the court finds probable cause. I'll hear from the parties.
I did speak to Mr. Prescott. I did advise him that he has a bond right now of $1,100. He advised me that, unfortunately, he has no one to post his bond. He's homeless. He's been here besides 10 years, his whole life. He gets disability. He gets about $738 a month. But he says he's not in a financial position to post bond, so he's asking the court if the court would consider releasing him on pretrial release. And also he wanted to know in reference to count 1, what was the alleged a controlled substance, which was found.
Trazodone.
All right, I'll hear from the state.
One moment, Your Honor. I don't have a problem with pretrial with random testing, Your Honor.
All right, so Mr. Prescott, you'll be released to, it'll be ROR'd to pretrial supervision, and that will include random drug testing. Mr. Romero's giving you the information for the pretrial office. You must report there by tomorrow morning. Failure to report, a warrant will be issued for your arrest. Do you understand, sir?
Yes, ma'am.
All right,
Judge,
good luck.
would you be inclined to waive the cost of drug testing?
Based on what?
Hector? 'Cause
Judge, he's homeless. He's financially injured. He filled out a financial affidavit. He's basically has no funds.
asking you to take judicial
Okay.
notice of the,
All right. Okay, Gregory Lewis?
Is that both cases, Your Honor?
Yes.
Mr. Lewis, come on up, please. He's approaching, Judge.
All right, Mr. Lewis is before the court for a petty theft charge. It's felony petty theft. All right, and the court finds probable cause.
Judge, I was talking to Mr. Lewis about this offense. One, I believe this is not in custody of Capias. When was the alleged date of incident on this case?
March of this year. It's
Judge, having
CVS.
said that, and speaking with Mr. Lewis, I see the standard bond 750. From what he advised me, he's not in a position to financially post that bond. He is working, he works for a renovation company. He's been there employed for 6 months now. But he basically tells me he lives paycheck to paycheck, and he lives with his mom who he helps out. She's elderly. She's on a fixed income. She receives Social Security, so she can't help post his bond. So what I'm asking the court to consider is on this nonviolent offense, if the court would consider releasing him on pretrial release.
Your Honor, he was put on pretrial release on a felony theft last year, and that was until he got arrested on a new felony theft and had his bond or release revoked in that case. He pled out 2 felony thefts last year, was sentenced to 160 days, released in January of this year. Felony theft 2017, felony theft 2016, theft 2016, felony theft 2016, felony theft 2013, felony theft 2013, theft 2012, theft 2012, theft 2010, theft 2010, theft 09. Goes on from there, Judge.
All right, based on the probable cause affidavit and the priors that I've just heard, and the previous violations of pretrial, I'm gonna deny the request for pretrial. Mr. Lewis's bond is $750.
Did you look in Odyssey?
Kimdry Lubin,
Mr. Lubin is here at Main, Judge. He's approaching. Come on up, Mr. Lubin.
I haven't been able to go through all of it. If you can just give me a moment on Mr. Lubin.
okay. We don't have Mr. Abasnina, is that correct?
No, Judge.
Jeffrey Thomas,
Mr. Lubin, or who? I'm sorry.
your attorney,
This is for
the
Mr.
attorney
Lubin.
needs more time
We're gonna recall.
on Mr. Lubin.
Have a moment.
Jeffrey
Have a seat.
Thomas,
Judge, I've been advised he bonded.
okay. Hemsley Tureen,
And Judge, the good news, he bonded as well.
okay. right, so, on the misdemeanor hearing docket, Luther Simon,
Let me tell you, Mr. Simon.
Conti facility,
E. Conti.
Conti. All right, Mr. Simon was arrested on June 7th, so he's before the court for a second look on his bond status. Let me see. All right, I don't have the, previous PC for Mr. Simon.
Your Honor, base, it alleged,
How much bond does he have, and is it,
it's $100 bond on a trespass.
was there something else at the time that he?
No, it alleges he was trespassing at the subway he used to be employed by and refused to leave. If he wants to resolve the case, the offer from the state be a withhold court costs, no return.
Sir, do you have the ability to post $100?
Yes, I get paid on the 14th,
Okay.
and that's when I'd be able to,
Do you wish
to,
do you wish
pay
to,
the,
do you wish to resolve this case and have it on your record, even though it's just a withhold?
plea, no contest.
That's what you wish to do?
Yes, sir.
Okay.
All right, Mr. Simon, please raise your right hand. Do you swear or affirm to tell the truth?
Yes,
You
I
can,
do.
you can put your hand down, sir. Mr. Simon, you understand everything that's going on here today?
Yes, ma'am.
Is
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
Not at all, Your Honor.
And do you need any more time to speak with your attorney?
No, Your Honor.
And you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
If I plead no contest, am I giving up that right?
You're giving up your right to go to trial if you take a plea today. If you plead no contest, you're resolving the case today. It'll be finished today. There'll be no depositions. There'll be no trial.
Will it be on my record, Your Honor?
You will receive a withhold adjudication, which means no conviction, but yes, it'll be there that you received a withhold adjudication.
It'll be an open record for anyone to be able to see.
Okay.
Do you wish to ask the judge for pretrial release instead?
Then how long will I be here if I ask for a pretrial release?
In jail?
Yes.
We would see, can we see if we can, judge would be inclined to release him on pretrial release?
All right, Mr. Simon, you have several options here, okay? You can post your bond and come back to court whenever court is reset, okay? Or you can resolve your case. We started going through the plea colloquy. That was for you to resolve your case, for the case to be over, not go to trial, and you take a plea and you sentenced to withhold adjudication and court costs. So, do you want to go to trial with the case? Do you want to resolve the case?
I do not want to go to trial with the case.
Well, do you want to resolve the case today?
Yes,
All
Your
right.
Honor.
So that's what we started doing, so is that what you want to finish doing?
Yes, Your Honor.
All right. So do you understand that you have the right to go to trial, but by taking a plea today, you are waiving that right?
Yes, Your Honor.
And have you ever been treated for mental or emotional illness?
Yes, Your Honor.
Is there anything about that illness that will prevent you today from making an intelligent decision?
No, Your Honor.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor.
All right. Then what plea do you wish to enter, Mr. Simon? Your two options are guilty or no contest.
No contest, Your Honor.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves withhold adjudication and court costs. Good luck.
Thank
All
you.
right, on our felony hearing docket, Gary Richards.
Judge North Broward.
Okay. All right, Is this correct that Mr. Richards' most recent arrest is April 6th?
Yes, Your Honor, the state did file an information.
Well, when he was arrested, were there other things that were holding him in custody?
Yes, he has an out-of-county bond. He's got bonds for violating pretrial and misdemeanor cases. He's got a total bond of $14,500, not including the $1,000 bond on this possession of cocaine.
All right, so, okay. All right, so, Mr. Richards, it appears that you have several other things reasons why you're in custody other than this case.
Yes, on the out-of-county bond, Your Honor,
On the what?
on the out-of-county hold,
The out-of-county hold, yes?
yes, that was not prosecuted due to lack of evidence. I don't know why it's on there. It was 2 misdemeanor charges that was on there. It's been well over 30 days. I was under the impression, I was told that after 30 days, I could be released.
Well, after 30 days, there's a motion that can be filed for you to be released, but not on the where are those out-of-county holds
It's
from?
Charlotte County, but they didn't prosecute it because of lack of evidence. And I posted a bond. Now, I never heard from the bondsman. I never heard from nobody, and my relatives got contacted or anything. I'm sure the phone will be ringing off the hook if I defaulted on that.
I don't know what happened on the
Your
out-of-county
Honor,
cases.
and I don't know anything about that. All I know is that it's obviously still in place because the jail still has the $10,000 bond on that count.
Okay,
If he has issues with Charlotte County's hold, he needs to either, I don't know, contact a public defender there, contact an attorney or his family.
I know
That's
your family needs to contact the
My
other
wife-
county, okay?
Is there anything I could do today to be released, Your Honor? My wife has MS, and we're running out of people to help take care of her.
I can't do anything with the out-of-county cases. The out-of-county, I cannot do anything with them. And this, this new charge has been filed. That's correct, State?
Yes, ma'am.
Okay. All right, so,
Can I talk to my attorney?
Mr. Richard, you need to talk to your attorney, okay?
Okay.
And see, what can be done.
I've been trying to.
All
Can I
right,
talk to him today?
okay.
Can I talk to him
Well,
today?
I don't know who your attorney is, so,
Looks like he's in drug court right now, so
Okay.
I'll email the drug court, and see if they can get him in for a hearing.
all right, okay.
What's gonna happen now, Miss Your Honor?
The attorney that's in the courtroom with me said that he's going to contact your attorney and, I'd let him know that, you need to talk to him, okay?
Yes, because I'd like to get, like I say, my wife has MS. I'm almost 70 years old. I'll be 70 years old this year, and
I
I'm
understand.
still being treated for third-degree burns over third of my body myself, let alone my wife's problems.
Okay. All right, so your attorney should be in touch with you, sir, okay?
Today?
No,
As soon as possible. Martavis Harvard,
He's approaching, Judge.
all right, Mr. Harvard was arrested on May 9th. So this is a 30-day motion?
Yeah, sure. The state has not filed an information. It's Mr. Harvard's call whether he wants to accept the ROR. He's being held no bond, and I believe in career criminal court on some very serious charges. So he's not getting released today, either way.
Okay,
I understand that, Judge. I understand that he spoke to Mr. Farberic, that's his early representation unit attorney. I looked at the notes Mr. Farberic advised him as far as what to expect regarding this case, that those holds are still there and those holds don't go away simply because this motion is granted. I believe Mr. Harvard made an informed decision and told Mr. Farberic to still place this on the docket, so he still wants to proceed.
okay, so I'll grant the motion. He's entitled to an ROR, okay?
I understand you're not getting credit for this while you're in custody, though.
All right, Michael Powell,
Here's Mr. Powell, Judge.
How you doing, Your Honor?
all right, Mr. Powell, you're before the court for a 30-day motion as well. What's the status?
Information was filed last Friday.
Last Friday? Okay. All right, Mr. Pell, they have formally filed the information. It was filed last Friday, so I'm gonna deny the motion for ROR at this time. Okay?
Yes, sir. That's all right.
All right, Eugene Anderson,
Mr. Anderson is in Conti.
okay? Conti, you have Eugene Anderson.
County facility, Your Honor.
All right, so Mr. Anderson was arrested on May 9th, so this is a 30-day motion.
This information was filed yesterday.
All right, and was it filed as presented at arrest?
Yes, ma'am.
Okay, so Mr. Anderson, you are on today for a 30-day motion for release. The state has informed me that they have formally filed the charges. So you should be going before your division judge shortly for arraignment. And as to the 30-day motion, I'll deny that today, okay? Curtis Hunter, yes,
Conti.
So I'm being denied for my ROR.
right. The information has been filed, so now you have to go before your division judge, okay?
And what will my court date be?
I don't have that information right now, but it should be shortly. Okay? Where's Mr. Hunter?
Conti.
Conti.
Did they show that a waiver was signed?
I don't know anything about your case about a waiver, sir. You have to talk to your attorney about that, okay?
Hunter? How you doing?
Hi, Mr. Hunter. Mr. Hunter is before the court for a 30-day motion. His arrest date was May 9th.
Information was filed yesterday, Your Honor.
All right. And is it filed as the original arrest?
1 and 2 were filed as presented. The trespass was filed as an armed trespass, and he was charged with carrying a concealed weapon by a felon.
All right, so, Mr. Hunter, just for your information, okay? So, the information has been filed. I'm gonna deny the motion for ROR. I can see that you have questions. You need to speak with your attorney, about, how you go forward from here, okay? James Dasher,
Mr. Dasher is here, present main judge. He's approaching. Come on up, sir.
okay? All right, Mr. Dasher is before the court. He was arrested on June 5th, so he's back for a second look at his bond status.
Correct, Judge. And speaking with Mr. Dasher, unfortunately, from what he advised me, he has, two parts. One, he doesn't have anyone contact because he doesn't have any phone numbers memorized and he doesn't have his phone with him. Having said that, even if he could get their phone numbers, from what he is telling me, no one's in a financial position to post his monetary bond. Now, he's been living here his whole entire life. He's 28. He said he's been looking for work and he's been successful. He's supposed to schedule to start a new job next week at a company called Teleperformance, which is a call center. Now, he lives in Pompano Beach with a roommate. He's been there for about 2 months. He's asking if the court would consider releasing him on pretrial release on these nonviolent offenses, Judge.
And I don't remember was there a history with Mr. Dasher?
First, he sold approximately 7.5 grams of field-tested methamphetamine to a detective in exchange for $500. And he was found to be in possession of additional methamphetamine and MDMA. At that time, he also had a warrant for a DWS that he failed to appear in court on. Priors include, late November 2018 at a Dade possession of cannabis. August 2018 at a Hillsborough County possession synthetic cannabinoid. Out of Dade County 2014 theft another theft in Dade in 2014. Armed robbery out of Dade County, 2014. Using anti-shoplifting device or countermeasure. Grand theft, 2014 out of Dade.
All right, at this time, I'm going to deny the request for our pretrial. His bonds will remain in place, okay?
Yes, Judge.
All right, and, Reginald Rosier,
Mr. Rosier, come on up, please. He's approaching, Judge.
all right, Mr. Rosier was arrested on June 6th, so he's back for a second look at his bond status.
Correct, Judge. My understanding, Judge, and speaking, Mr. Rosier, I didn't do the math yet, but I believe it's well over $2,500 or $2,100, Judge. And that's something he cannot afford. My understanding right now, he's not working. He actually has some medical issues, and he's looking into the process of applying for disability. Now, he lives in Hollywood by himself. He's been there for about 2 years. But from what he tells me, there's no one that he can contact at this time to help post his monetary bond. So he's asking the court to consider releasing him under supervision.
Your Honor, first, this case involves stealing from the same Dollar General, May 31st, $272 worth of property. February 16th, $100 worth of property. And then it looks like on June 6th, the day he was arrested. Additionally, he's been arrested April 26th of this year on a capias on a theft that he pled out. May 3rd, a new theft that he pled out. Carrying concealed weapon that he bonded out on. And then that's still pending. And then these charges. And that's just local here in Broward.
All right, it looks like, and he currently has 3 more petty thefts. It looks like it starts out saying, that the store identified him from previous crimes after he had just committed this new crime, so I am gonna deny the, release.
Okay, Judge. The only thing I just want to, and speaking, Mr. Rosier, and hold on, don't let me do the talking. The only thing I just want to clarify on what Mr. Lunder said, and I had an opportunity to actually review his PC affidavit before coming in here, and I saw that there was probable cause found for 3 felony petty thefts. When I read the PC affidavit, I believe on the day they identified him, they didn't claim he actually stole anything on that day. They've identified him from prior incident, and then they list 2 dates. So I don't know how probable cause was found on one of the felony petty thefts. But and Mr. Rosier wanted me to bring that to your attention. I'm advising him. I'm sure a case filer will see that, and if that's, it won't, that count won't be pursued. But he just wanted me to bring that to the attention of the court.
Yeah.
Okay. All right. Bradley Shield,
He's approaching, Judge. You're present, Judge.
all right, and Mr. Shield is before the court. It's a second look at his bond status. He has a total of $1,000.
Your Honor, the defense was asking for drug treatment. Your Honor advised they could seek that in division. He was mentioning a program that he had gone to in the past.
What happened with that? Well, that was only a few days ago.
Yeah.
So someone needs to look into that for Mr. Shield, okay?
Well, Mr. Shield is asking me at this time, Judge, to consider releasing him on pretrial release with random drug testing. Now, he did advise me right now he is working. He works at an auto body auto body shop. And that, employment is still available to him. So that's why he's asking for, if on this nonviolent offense, if the
Your
court
Honor?
consider releasing him.
Your Honor, actually, yeah, it was 3 years ago. I completed the first step program house. All right, I was there 8 months. I was on charge of possessing cocaine. Always I have a problem, Your Honor. All right, but I do work and I do live. I reside, but I have completed the program. I like the program. Yeah, I can go there today if I want. They'll take me back with open arms. You can call him. His name is Kelly, and Kelly and Chucky run the place, and I'm sure they'll welcome me back with open arms. I have no problem there, Your Honor. That's where I plan on going back before I got arrested. I was going to go there and ask to go back in, which they would welcome me back with open arms. I still have my job. I can work there, Your Honor. It's,
Mr. Shield, we had the same conversation a few days ago. And, so you need to speak with your attorney. If you want to go to First Step Sober House, then somebody needs to get an assessment done, and then you can figure out if they'll take you back, okay? At this time, we're gonna leave the bond in place. All right, Kalfani Phillips,
On posted, Judge.
on posted, okay? So I'm ready to address Robert Pellegrino.
Judge, I don't have a PC and Odyssey is not loaded.
Your Honor, and all I can
Right.
say,
This is a
Well-
KPS at charge.
is he there? He might not be
Is
because,
Mr.
Auntie
Pellegrino,
facility, Your Honor.
where?
Auntie facility.
Okay.
Your Honor,
How you doing, Your Honor?
Hi, Mr. Pellegrino.
I'm asking the court to find probable cause based on the not in custody capias that was properly issued by the clerk's office, the ad charge capias based on the state filing an appropriate information. Your Honor, Mr. Pellegrino was arraigned by Judge Merrigan this morning on this charge.
Okay.
That
Considering-
was actually yesterday. I was arraigned
Okay.
yesterday, Monday morning, but not for this charge. I was arraigned for grand theft. So this tampering with a witness, I have no idea what this is. I have no
Don't talk about
witnesses
the
in my
facts,
case.
okay? Don't talk about the facts.
And Your Honor, I can assure you,
But I don't have no facts about this case. It's a witness. I have
Stop
no
talking about the
witnesses.
facts. We got it, okay?
Okay.
Your Honor, I'm looking at Odyssey 196026, CF 10A. It says his arraignment was held June 10th, and there was a plea was
I'm
entered.
sorry, it's 1900.
6026, CF 10A.
26 CF10A, and that's the ad charge?
Yeah, it's right there on the plea and the arraignment.
Okay. Let me pull it, where the probable cause for tampering.
And he was before the court for this
And
ad
frankly, I don't know
charge?
and I don't know if it's gonna be in the probable cause, Your Honor, for all I know, it could have been from a sworn statement taken from the victim or the witness in this case who was an employee at the cell phone store that he allegedly committed the grand theft. Your Honor, the argument I'm making at this point in time is, the question is he lawfully being detained on this charge? At this point in time, the state filed an information in an ad charge pursuant to statute. The clerk's office issued the ad charge capias, which BSO is now detaining him on that charge pursuant to a lawfully issued ad charge capias.
All right, so,
Judge, if I can be heard?
Sure.
Sure. Judge, the case is Gerstein versus Pugh. It's a Supreme Court case from 1975, and it holds that even if an information is filed, that's not enough to hold somebody. You still have to have a probable cause finding by a neutral and detached magistrate, because the enforcement arm, the executive branch, can't just go forward alone. The citation is 420 U.S. 103 114, and it actually regarded Florida state charging document, such as an information, but no probable cause determination was ever required. However, the defendant brought a civil action because of that. The Supreme Court ruled that to safeguard citizens from rash and unreasonable interferences, it requires that a neutral and detached magistrate make a probable cause determination rather than law enforcement officers who are engaged in the, quote, competitive enterprise of ferreting out crime. Although practical considerations allow police to make undetermined, that doesn't justify dispensing with the magistrate's neutral judgment evaporated. So the Supreme Court held the Fourth Amendment requires a judicial determination of probable cause as a requisite to extend restraint of liberty following an arrest, even if an information is filed. And this overturned Florida.
And Your Honor, I'm basing this on the capias that was issued.
The capias wasn't issued by a neutral and detached judge. Probable cause still has to be made. And I have nothing in front of me, nor does the court, to show probable cause for tampering. I have case law that I could argue that doesn't make it tampering if I knew what the facts underlying it were.
How could you have case law to argue when you
Because-
know what the facts are,
because-
but you're saying you have case law to argue against the facts?
I could.
On the information that you've provided, there's information filed as to the tampering?
Yes, yes, Your Honor. He was advised yesterday by Judge Merrigan, based on the information, what he's been charged with.
Being advised is not probable cause.
I
All right,
wasn't
well,
saying that.
based on that information, at this time, I am going to find probable cause.
So Judge,
Let's talk about the
just to be
bond.
clear, you're finding probable cause based on no evidence presented just because the information is being filed?
Yes,
Okay. I'm gonna take a writ for it.
okay,
Okay.
Your Honor, I'm requesting a $500 bond. He has a no bond hold, court order no bond hold out of grand theft.
all right, $500 bond. All right, as to, finding probable cause based on the KPS and also the information that's been filed.
Eric,
Okay.
where's the rule
Kimdri Lubin,
that allows for that if an information's filed?
Mr. Lubin, come on up, please.
I think the court's moved on to the next case and not.
But is there a
It's not
rule?
my job to do your research for you.
Is there a rule?
Kimdri Lubin,
I have one. Can I have one question before you call the next person? Here, me. I didn't see this charge until this morning on my records, like on my kiosk upstairs. It just popped up this morning. Was not aware of it yesterday in court. I was only aware of the
that's
grand
why
thefts.
you've been brought for first appearance today, okay?
And it was filed already?
So talk to your attorney, okay? All right, Kimdri Lubin,
He's here, being judge.
all right. Mr. Lubin is before the court on charge number 1 is possession of cannabis, 20 grams or less. Number 2 is robbery, no firearm or weapon. And number 3 is burglary with assault or battery.
Your Honor, he has family here as well that, we should-
Okay? Good afternoon, folks. All right, the court finds probable cause. We'll hear from the parties.
Your Honor, the state would be seeking a no bond hold on count 3 upon a finding of proof evident or presumption great for first appearance purposes only, relying upon the arrest warrant affidavit of Detective Neil Munson of the Broward Sheriff's Office. Noting the allegations are that Mr. Lubin and his co-defendants, through fraudulent means, obtained entry to the victim's room at this hotel, laid in wait for him to return, and once he did, 2 of Mr. Lubin's co-defendants chased the woman that he was with outside, threatened her, and the allegations are that Mr. Lubin and 2 other co-defendants physically attacked the victim in his room and stole his cell phone. Also noting that Mr. Lubin was identified by the victim with 100% certainty.
I do remember this affidavit. Are the other persons in custody and Mr. Lubin was not? Is that the
No,
case?
one moment. As far as I know,
There
the
was at
only
least
two,
one or two people that came through.
yeah, the only two I'm aware of, and that isn't to say that others haven't, Your Honor.
Okay.
We're not here on the weekend, I don't know. Would be Charnay Wright. Yeah, no, I'm just looking up the information too. One moment, Judge.
That's okay. You don't have to tell me who.
Oh, okay.
I'm just wondering if,
The two, I believe it's the two females that allegedly chased the female victim out of the room.
okay.
And, Your Honor, Ms. Wright, I'm just trying to find. Okay. One was Brittany Severe. You said her bond, I think you found proof evident presumption grade. You exercised your discretion and set bonds. You said her total bond at $5,500 and Ms. Wright's total bond at $7,000.
We would have objection to probable cause because although it's alleged that he entered surreptitiously into the hotel room, it can't be distinguished that he entered with an intent therein to commit a battery or burglary. He entered and remained in there, and so they have to charge him under that specific clause, the remaining in clause. And there's nothing to show that he had the intent when he entered of committing a battery inside. I'm relying on Tinker versus State, 784 Southern 2nd, 1198.
Your Honor, first off, I think there is enough factual allegations to draw a conclusion that there was an intent before entering. That being said, that's a moot issue for today, considering this is based on an arrest warrant that Judge Ari Porth signed, thereby finding probable cause pursuant to the rules of procedure.
And also, it was the same probable cause affidavit that two other persons were held finding probable cause on. And based on the affidavit, Mr. Lubin was part of the group that went and waited, per the allegations, for the alleged victim to return. And then he was kicked and beaten, whatever. So the court does find probable cause as to all those counts. I know the state has asked for proof evident presumption great.
I would rely on the same arguments of
all right.
exercising discretion and not finding proof evident presumption great.
Okay.
Judge, just to piggyback on my colleague, if Your Honor does find proof evident presumption great, I do realize that from what Mr. Lunder just stated, that the two other co-defendants, the court did exercise their discretion. I'd be asking for the court to exercise their discretion in this case as well. My understanding is being Mr. Lubin, I believe he has very limited contact with the criminal justice system. I believe it was a drug offense that he went through diversion on, but he's been here his whole entire life. He lives with his mom. His mom is, I know she's on disability. She's dealing with health issues. He's gone to school here, graduated from Lauderhill High School class of 2014. He just went ahead and basically had an interview, and he was hired at Majestic Car Wash, and he was supposed to start work tomorrow. Judge, this is a person that from the moment he sat down, he was really confused as far as what was going on, but he did tell me he's going to be coming to court, and I'm sure by the fact that his mom is here for support, she's going to make sure that he comes to court. I'm just asking the court exercise their discretion.
All right, Mom, good afternoon. Is there something you wanted to say? I mean, I know you don't have to. The attorneys are speaking on his behalf, but, you're standing
Still a
here.
little bit blurred of what's going on or
Okay.
when did everything happen, because just last night when they came in and bushed and arrested him, and he was clueless upon what's going on. I myself don't even know anything happened or even overheard. But I'm saying like the bond and everything else is so high, and there's no way I have that money to do it. And on top of that, tomorrow's my birthday on top of that. So I'm on disability, getting $1,011 a month. And I'm living with me and my four boys, a family of 5. And my health is not, I don't have the best of health,
Okay.
but I'm pushing. This is really news to me, and it's really a bit stress for me.
All right. I believe, I don't know if I said that on the other times that, I don't know what, I know it's not Mr. Lubin who was the author or the master, well, the person who created this whole distraction and brought people there, so I'm not, I'm not gonna treat Mr. Lubin differently than the other ones. I did make a finding of proof, evident presumption, great, but I did exercise my discretion to set a bond. And, state, what, did you say that he has a record?
He had the felony drug offense that Mr. Romero mentioned, that he
Okay.
did complete drug court. I did, reviewing that case, I did see that no bond capiases were issued on 2 occasions for failing to appear in court. Ultimately, Judge Porth put him on an electronic monitor.
How much, you told me on the other bonds, it was 5,500 and 7,000
Yes, ma'am.
on counts 2 and 3?
Yes, on those 2 charges, yes.
Okay, all right. All right, so at this time, what I'm going to do is, did we say 5,500?
Here, I'll pull them up right now. On one co-defendant, you set the bond on the strong arm robbery at 5,000 and 2,000 on the Bergbat. On the other co-defendant, you set the bond at 2,500 on the strong arm robbery, 3,000 on the burglary with assault or battery. Frankly, Your Honor, I think part of what went into the court's determination on Ms. Severe's case, you set the lower bond on. I believe she had a family member here. Yes.
All right. All right, I understand. All right, so on count 2, I'll set the $2,500 bond, and count 3, 3,000, okay? No victim contact. So that means no phone calls, no text messages, no social media, no third-party contact, no contact with the other co-defendants, no talking about the case with anybody else, okay? All right. All right, good luck, folks. All right, I believe we're at the end of we have covered all the dockets.
We have one more person, Judge,
do?
Mr. Jeffrey. Mr. Jeffrey, come on up, sir.
Mr. Jeffries on which docket?
On the felony second look docket, Judge? How do you pronounce your last name again? Kuntz. Mr. Kuntz, Jeffrey Kuntz.
You have
He was set by.
I don't have that.
He was set by pretrial, but he didn't make it onto the clerk's docket.
Oh, because I don't, when was he arrested?
He was arrested June 7th, I believe, Judge?
Came through over the weekend. The
Oh,
reason it wasn't set on the docket, Your Honor, is he doesn't have a case number yet, because he was arrested on an arrest warrant.
oh,
He'll be brought back tomorrow.
all right.
Okay.
All right, thank you, everyone.
Judge.